Good morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Hausmann Johnson Insurance. I would like to welcome you to today's webinar on discipline, termination, and how to handle a difficult employee, presented by Karen Bender. Today's webinar will run the full hour. If there is time after the webinar, we will have a question and answer session. If you have a question during the webinar, feel free to type it into the question feature and Karen will address it. After the webinar is over, there will be a short survey we are hoping you can fill out for us. A note that this webinar has been certified for continuing education credits by the Society for Human Resources Management and the Human Resources Certification Institute. Details on those credits will be provided to you at the conclusion of this webinar. Also, please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in the recorded webinar, you may want to close the application at this time. You will receive a follow-up email from GoToWebinar with a link to the recording and the presentation slides. I would now like to introduce you to our presenter for today's webinar, Karen Bender. Karen joined Hausmann Johnson Insurance in 2017 with over 30 years of human resources experience. Her experience includes regulatory compliance, including FMLA, EEO, FLSA, HR, and safety, benefits, wage and salary administration, employee relations, training, and payroll. The majority of her industry experience is in insurance and manufacturing, and she is knowledgeable in both union and non-union environments. Karen also provides training services to the UW-Madison Small Business Development Center in HR areas and instructs a class for the UW-Madison Division of Continuing Education Studies. Further, she develops and teaches courses targeted at providing small businesses, those less than 100 employees, with general HR guidance and employment law review to help them maintain compliance and improve their processes. She has a wealth of knowledge on this topic, and we are very thankful that she could share some of her wisdom with us today. Welcome, Karen.
Thank you, Suzanne. Good morning, everybody. We are going to talk about discipline, termination, documentation. It's all very complex, or it can be at times. So we are going to talk about some of the main parts, but there are a lot of ancillary parts to this process that we will not be able to get to in the next hour. For example, items such as creating a culture of accountability where one does not already exist, severance, performance management plans, performance improvement plans, etc. We will not be able to hit all of those topics. We're going to focus more specifically on some discipline and documentation issues. Because we know we won't be able to get to all the issues and all the questions, we will be using the Q&A feature. Please send your questions in and we'll get to as many as we can, and I will respond to all with any questions that we do not get covered in the next hour. And if you need further training for your leaders or your supervisors on site, you can indicate that in the survey at the end, and I'll get back with you to discuss your needs. So today we're going to talk about the purpose of discipline and documentation and the consistency. Why is consistency so important? We'll talk about that, typical steps, and how to deal with some of the complications that will inevitably arise. So the purpose is to provide you with the foundation of knowledge, to give you the confidence and skill to handle situations when they arise. A lot of times we don't handle situations because we don't know how. We're not confident that we're doing it right, and we don't know how to properly handle a very difficult situation. I am not an attorney. I will be providing you with information that I have developed and training that I have developed and from my experience and from research, but this is not to be construed as legal advice. So what is the purpose of discipline? bottom line, purpose of discipline is to change behavior. That is, if somebody is doing something wrong, you even think about it with your kids. If you have to discipline your kids, your goal is to change behavior. Bottom line, you either want to have them start showing a favorable type of behavior or have them stop a negative type of behavior, improve their performance, get to work on time, whatever the issue is, this is the goal of discipline. So why is it so hard for people to do this? A lot of my clients really struggle, especially the first time that they have to discipline somebody. They're very nervous about it. Many people, even higher up in organizations, are still nervous about it. And it's hard because it's uncomfortable. Many times you don't know how people are going to react. There could be anger, there could be tears, there could be yelling. There's just a variety of things that can happen. And bottom line is we want people to like us. So it is hard to have a difficult conversation with people. It's easier to ignore the bad behavior and hope that it will go away, but generally it doesn't. And oftentimes we don't know what to say. So hopefully after some of this training today, you'll feel more comfortable dealing with this tough topic. Wisconsin is an employment at will state. So because of the fact that we can fire people with no notice, for no reason, as long as it's not illegal, why do we have to do all of this stuff? Why do we have to document and discipline and walk through all of the steps? Well, you're wondering, why can't I just fire the people I don't like? Well, legally you can, but that does not mean you should. If you do that, if you terminate people without discipline and without consistency and without thought, you could have your decisions challenged. And even when you go through all of the steps of documentation and discipline, your decisions can be challenged. But if you have the documentation, you'll be able to support them. If you are not methodical and thoughtful in your processes, you could end up in hot water and with claims against you. Even with claims against you, again, with the documentation, you may be able to defend yourself. And the consistency in your decisions on how you treat your employees will deeply affect your morale and your ability, again, to defend yourself. So what is the purpose of documentation in this process? You have to capture the facts of an incident. And those facts can become a legal record. The facts, and we'll talk about capturing the facts when we talk later on when we're talking about documentation, but capturing the facts will help protect and defend the company. They could make or break your success in a legal situation if somebody files for an arbitration or files a charge or sues you or does anything like that. Your documentation will be critical in defending yourself. Also, it's important to maintain that record because our memories fail. Many of us have had situations where we think, I will never forget what they did and what happened and this whole incident that we're dealing with. But your memory will fail because the next incident that will come along will be on your mind. Managers move on and they're not there. If they don't document what happened and they've moved on, you don't have that record. But if your memory fails and you don't remember the times, the dates, and all the details, that record doesn't do you any good unless it's documented. And again, consistency is vital. And we'll talk about that some more, about treating your people consistently. So the documentation is also written proof of your steps that you've tried to work with this employee. Nobody wants to be blindsided. Put yourself in the employee's place. How will they feel if they are not treated fairly? How will their coworkers feel if they're not treated fairly? When you're disciplining somebody, did they know the rule? Have they been trained? Did they know what they were supposed to be doing? Employees should not be surprised if they are disciplined or terminated. They should have known, and it's your obligation to ensure that they knew what the rule was and what the consequences were for breaking the rule. And did they have the training that was needed? Do they have the ability? Or are they in a job where they don't even have the ability to do the job? You still need to walk through the steps so that they have a fair chance. And walking through those steps of the documentation and the discussions helps to ensure that you're treating people fairly. If you document discussions of, let's say, take something pretty basic, if you document discussions with people on attendance, if you have a policy or if you don't have a policy, if you document your conversations that you have with your employees regarding their attendance, the next time that somebody's due for a discipline or documentation of an attendance issue, you can look at your prior ones and say, okay, well, this person, we let them be late 8 times before we wrote them up. Why do we want to discipline this person after 4 times? Is that fair? It also helps you when you're crossing different departments. If different departments are treating their employees in a different manner, the employees are likely to know about it. If they don't want to be treated differently in one department than in another department. For example, if somebody can get away with 14 absences before they get written up in one department and the other department they get written up in 4, they don't like that, and that's inconsistent, and it's harder for you to defend. So if you have the documentation that you can refer back to, you have a better or an easier job of defending your actions. So what needs to be documented? Okay, the law requires documentation on some things, and they're listed here. And these are for a variety of reasons that these documents need to be maintained. But beyond that, what should you document? So document behavior that may need to be recalled for performance. So good or bad. If you have, let's not forget that documentation should be occurring for good behavior also. You'll want to remember at annual review time if somebody did a particularly good job at something. You also want to be an employer that recognizes good behavior and not just the bad behavior. So make sure that you're documenting anything where there's like a rule violation, or where if this behavior continues, it's going to affect the performance of the individual or others around them, or the performance of the company. Any activity that can support that you treated employees consistently is another key to your defense. I know I use the word consistency a lot. Anybody that's been through any of my other training knows that I do that a lot, because that is very key to being able to defend yourself if you're treating everybody fairly consistently. So be sure that you do not discipline for legal acts. Employees have legal rights to reporting to different agencies. For example, they have the legal right to call OSHA on a safety issue. They have a legal right to take FMLA leave or other leaves provided in your policies. In my experience in talking to some of the clients, we see that that's when a manager or supervisor will typically want to get rid of a bad employee. They are out on leave anyway, and they'll come to you and they'll say, you know what, they're never here. I discovered I don't need them. Let's just fire them. They just told us that they're pregnant. They have a disability. Whatever the issue, you have to ensure that you are not disciplining for taking a legal protected action. But let's say somebody is due for discipline, and then they decide that they're going to go out on FMLA, or that they're going to call OSHA on you for a safety issue. Does that mean that you don't proceed with the discipline? Not necessarily. You must ensure that your documentation supports the process of your discipline thought pattern, and then make sure that it is not at all in retaliation for the fact that they've exercised their legal right. In other words, if somebody's due for discipline and then exercises one of these legal rights that's listed on here, proceed with caution, but that does not mean that you have to totally back off of the discipline if it was warranted. So disciplining specifically for safety violations can help you if you have a work comp claim or accident. So, for example, if you have an employee who you have trained on proper machine operation, and they've had the training, and they violated the policy, and you wrote them up, and so you have this documentation. Well, let's say that they violated again, and if you have got your documentation, if they've been trained, they know the right way to do it, they violated the proper manner of doing it, and you wrote them up and they did it again, you may be able to discipline them or even terminate them for violating the rules. You must proceed with caution, though, when you're terminating for a safety issue, because you have to make sure that they've had clear and specific training, that the disciplinary process is part of the program. They need to understand that they can be disciplined for violating the program. It has to be clearly communicated and used progressively. I would be careful in exercising the opportunity or exercising the option of disciplining or terminating somebody if you haven't done all of these steps. If you are developing a safety culture and trying to put more emphasis on the safety aspects of your business, you may need to walk down this road of disciplinary action for safety violations. But make sure you can prove that that employee had the ability to do the job and knew the rules before you start doing that. There is a link at the end of this presentation that talks a little bit more and goes into more detail about disciplining for safety, but that is a potential resource for you if you want to read more on that at the end. Oh, and what documentation is your responsibility? From the company standpoint, your supervisors or leaders should be documenting anything where they're coaching and counseling their employees. That might be handwritten notes that they throw in a file at the end of the day. It may be in their daily planner. It may be electronic. It may be an email to you saying, or to their supervisor saying, I warned so-and-so today about this violation. But any notes regarding a violation should be referred to HR if that's your company culture. Not every company, not every company sends this to HR, but once you decide what your company culture is and your company's processes are, you might want to consider referring all these notes to HR. Sometimes a supervisor or a leader is not aware of some of the other aspects that are going on. So, for example, HR may be aware of a potential harassment investigation, for example, and if they are aware of all the other issues that are involved in that, they have a better opportunity to do a fair and impartial investigation because they'll have more information. So your each facility will have to decide what's appropriate, but it may be appropriate to refer things to HR also from the standpoint of ensuring fairness across departments. If HR is involved, then they can see whether or not people are being treated fairly, as we talked about before. When you send notes or make notes regarding something that you've observed or seen or documented or wrote somebody up on, talk about who, what, when, and where. So, for example, employee A by the warehouse by the warehouse door at 4 p.m. on Tuesday did this or whatever, but don't talk about necessarily why they did something, because unless the employee tells you why they did something, you don't know what their motivation was. So be careful with that. If you ask an employee during the part of the investigation or as part of the discussion why they did something, then you can include that in your notes. But otherwise, if you don't know why, don't guess. So typically, you want to document any violation of company policy. And when I say document that, that doesn't mean that you're always disciplining, sometimes, or doing a formal discipline process. Sometimes it's a verbal. Sometimes it's, hey, just a reminder, hey, you took too long on your break. Let's get back on, on the right break, or any other items like that that are not severe and first-time notices. Might just be a verbal warning, but maybe you want to document that so that you can have that for future references when you do get to disciplining with the documentation. So you want to typically do attendance issues if that's important to your facility. I've worked with some of my clients that don't do any discipline in that area, and then it gets out of hand, and then they want to start doing it. But you can't always go back and recreate that stuff. Discipline, you want to document any performance issues. Is the person not meeting their deadlines? Are they being rude and inappropriate to other employees? Then that would be something to document also. If somebody needs training, if somebody tells you, you know what, I can't do this portion of the job without some more training, you want to document that. And document also, again, when somebody does a good job. Comments made by employees, be specific about those. If employees make comments to you, perhaps they will be making comments that will tell you or an indication to you that they're looking at reporting you to OSHA, or they're considering having, that they saw somebody violating one of the policies and stealing something. You make sure that you document those comments, and again, be specific and detailed on that. All disciplinary actions should be documented. The initial notes that support them, all the steps, including termination, should have documentation to support it, because, again, you are not going to remember all the details of that if for some reason you're challenged later. So it has to be documented to prove that you went through the steps. If you are having to make decisions about demotions, promotions, layoffs, etc., document your reasoning for that. Why did you decide that this group was going to be demoted, or why this person was going to be laid off as opposed to others? That may defend you in a discrimination claim on age, race, sex, or anything like that if you can support your decision. So how do you document? I've talked about making sure that you document who, what, when, and where, but not why. But when you're documenting that, you have to sometimes take a step back. You have to be factual and fair and objective. And sometimes we see things or feel things that are not fair and objective. So we have to, that's why I say we have to take a step back and remove any emotion that we may be having about the incident. Avoid opinions, name calling, labeling. For example, don't say somebody has a bad attitude. What's that mean? So you have to describe a bad attitude. Maybe, what's it look like? Maybe it's arriving late for work every day, leaving early, taking long breaks, not interacting with their coworkers appropriately, and not doing a good job, barely doing what's acceptable. That might all indicate a bad attitude, but it's more helpful if you describe what that looks like. If you describe, okay, well, if you say somebody's lazy, what's that mean? Talk about their actual behavior. And sometimes when you first start doing this, it's hard to think of the right words to describe that. So if you need help, get some help with talking through what the right words would be. What are you observing that makes you think that they're lazy? Okay, well, they fell asleep at their desk. Well, okay, describe that as opposed to lazy. So what did the employee do or not do? Again, be specific because it will help you identify what needs to change, but it will also help you when you have your discussion with the employee. So when should you do this? Do it as soon as feasible after the occurrence that generates the need for the documentation. Don't go back and try and recreate that. So for example, if you don't keep any records for attendance and then you decide that somebody's been missing too much but you don't have those records, how are you going to, you're going to go back and create them after time has passed? That doesn't work. The employees will be able to, if they saw a list of the days that you're saying that they were absent, they may know or not know that they were there, and it'll erode your case if, if you're not being honest. And we can often tell if you're not doing it on fairly quickly after the occurrence. That reflects badly on you because it affects your credibility. And sometimes when you have to go to court, your credibility is everything. If it's a he said, she said, credibility is going to be the tiebreaker in a situation like that. So typically, the written documentation, let's say so somebody has violated your rules and now you feel like you have to write them up. There's typically, I recommend 3 parts. Tell them what the infraction was, how you expect them to act in the future, and the consequences if there's future incidences and they haven't changed their behavior. I'm going to give you some examples. So here is an example of some documentation that I've seen in the past. You ran bad product and you didn't fix it right away and you didn't tell your supervisor. Okay, that doesn't tell you the amount of time, the amount of cost, and the whole process. And if that's the full write-up, it doesn't tell the employee what they should have done, and it doesn't tell them the effect of future consequences. So here is a better example. You are receiving this first written because you allowed poor quality product, unsealed packages to run to the packaging operator for 5 minutes today before you corrected the problem. Resulted in lost product valued at approximately $250. Our expectation is that you constantly monitor your machine in order to minimize waste, and if you're not able to fix the problem quickly, notify your supervisor immediately. Future infractions will result in further disciplinary action up to and including discharge. Okay, so right from the very beginning, it talks about specifically what the employee did. They ran unsealed, poor quality product, and it's specifically what the product was, for 5 minutes today, and it resulted in a product loss. And then we talked about what their expectation is and what happens in future situations. So that is going to be much more useful to the employee when it comes to changing their behavior, when you've told them what the expectation is, and it also is going to be much more useful to the company if you have to proceed with further discipline documentation. Here's another one that I have seen. you're not wearing your earplugs like you're supposed to. Okay, well, that's pretty general. And so you will see on here that I use the numbers 1 in parentheses and 2 in parentheses, and I'm going to define for you on the next couple slides why I did that. So we're saying over the past few weeks, I've told you on at least 3 occasions to wear your earplugs. As you know, we recently determined that you're working in a high noise area, and noise-reducing earplugs are now mandatory. So then we talk about them, they're receiving their first warning because they're out of compliance. Expectation is you always wear the earplugs, and future infractions will result in further disciplinary action up to and including discharge. And by the way, I put that last statement on every document or every disciplinary document I do, whether or not it's a first or second, third written or a letter to the employee, because sometimes we do final written warnings or last chance agreements, and I always put that in everything. Even if I don't think the issue is going to happen again, it's just standard default language. Now let's talk about 1 and 2. Over the past 2 weeks, I have told you on at least 3 occasions to wear your earplugs. Okay, so if it's a minor issue, a relatively minor issue potentially, such as wearing your earplugs in a high noise area, it may be a situation where you walk by somebody and say, hey, you know what, you don't have your earplugs in. Well, maybe the first time you don't write them up. And then you see them again, and you don't make a note of it because it's truly not on your radar that this is a big deal. So then the next week you see that they're missing them, and then you tell them again. And so on at least 3 occasions, by doing this, you're capturing the fact that you've told them about this, even if you didn't write them up for it. So if you didn't make notes as to when you told them that, but yet you remember that you told them, even if you didn't write them up, you know that you told them 3 times, it documents the fact that you told them 3 times before you wrote them up. So that shows fairness, and it shows progression in the process. And as far as number 2, as you know, the company recently determined you're working in a high noise area, and noise-reducing earplugs are now mandatory. This documents the fact that they were advised earlier, and you're telling them again. And again, it shows fairness and progression because it's reminding them that they've already been told. Once the employee has signed this reprimand, it makes it harder for them to go back and say they weren't told, as documented as on the first 3, on number 1 showing the first 3 times you talked to them. And it also makes it harder for them to say that they weren't trained, because now they'll have signed this document and it says, I was told and I was trained. And again, you're showing fairness and progression. So when you're doing the write-ups, what I didn't show in my examples is the actual date of the infraction and the actual date of the write-up. Also include your name, title, and signature. I've seen way too many disciplinary documents that don't have any of that information, and they're not any good. Typically, companies will look at performance. When they're doing performance or disciplinary actions, they'll go back up to about 12 months. But if there's nothing indicating the date of an action on a document, it is not very useful at all. Other facts, like we talked about, for example, the costs of what they did, the facts regarding the behavior, the time periods that this behavior was demonstrated, etc., that all reflects the severity of the issue. Is it minor? Is the cost, a few minutes' time? Or is the cost several thousands or tens of thousands of dollars? All of that reflects the severity and helps you decide the appropriate action, and allows you, if something happens again with another employee, it helps you determine, again, what's fair and for that employee based on the issue that occurred. Timing is important. So give the discipline as soon as feasible after the occurrence. If you tell an employee or tell somebody that their behavior was really out of line and warrants disciplinary action, you're going to send a message that it wasn't very far out of line if you don't address it for a week or 2 weeks or a month. I've seen some discipline occur a month after the incident occurred, and by that time, everybody has pretty much moved on, and it's not as relevant. Praise is important to give as close to the time that the behavior occurs, and so is discipline. They're both very important that they be done quickly. However, in some cases, you will have a situation where you have to do an investigation. I recommend that if you're going to do an investigation into somebody's behavior, to tell them. Tell them, let's say that it's a harassment issue. I would, have them they'll probably be a part of the investigation, and tell them that you'll get back with them after the investigation, but that may be a few weeks. However, the employee has been told and is aware that their behavior was inappropriate, and you're investigating before you do any action. Sometimes it's appropriate to, I'm going to go back. Sometimes it's appropriate to suspend somebody from the facility while you're doing the investigation. If the behavior that has been reported or observed by you is severe, you may want to suspend them. But at the time of suspending them, of course, you're telling them that they are being suspended because of their actions. If you have an employee assistance program, consider recommending that. Put that on the actual evaluation. Tell them that you recommend that, so for example, on the attendance ones, if it's a situation where people are not treating other employees well, or harassment, or any issues like that, consider telling them to seek the EAP. Document that on the performance or on the disciplinary action so that they are put formally on notice that this is available. That is another step for you to show that you tried to help this employee. It's another route for them to go to get help. But be careful and do not counsel them at all if you are not a professional in this area. If they are having personal problems or any of the other issues that are listed on here, and you are not a trained professional, and you counsel them on what they should be doing and how they should be treating these issues and stuff, you are opening yourselves up to some liability in that area if you're not licensed or licensed professional in those areas. You can express, if they talk to you about the fact that they're having all these issues, you can express your sympathy for them and encourage them to go to the EAP, but do not counsel them, because if they take your advice and do the wrong thing, you may have some liability. As I stated earlier, that if the situation is serious, you can suspend them, but make sure that you keep the investigation process moving along so that it doesn't become excessive time. You don't want them out for a month, 2 or 3, while you're doing the investigating, because that's excessive and rarely would be appropriate. The non-exempt employees do not need to be paid if they are not working, unless you have some other agreement with them. There's no pay due to them if they're not working under the law. However, also under the law, salaried employees may be required to be paid unless the suspension is for a full work week and it's for a serious safety violation. You should be holding your exempt employees to a higher standard than your non-exempt. in situations where salaried employees have to be suspended or where it warrants suspension, sometimes we'll just go to termination or paid day or two for them to think about what they're doing. But you have to be careful with exempt employees not to suspend them for partial weeks under the Fair Labor Standards Act. And if you do the full investigation and that reveals that nobody did anything, that the person who was suspended didn't do anything wrong, you should consider paying them for the time that they were suspended because you made an error in suspending them when they didn't do anything wrong. That doesn't mean it wasn't appropriate for you to suspend them for the investigation. But it just would be the right thing to do if you find that they were that no wrongdoing on their part. It feels like it would be appropriate to pay them for the time that you sent them out. Typically, there are 4 progression levels to discipline. People use different terms at the first level. They'll call it a verbal or a first written. Some companies call it a verbal and then they reduce it to writing. There's a second written. Typically, the third step is a suspension and the fourth is termination. So review your progressive disciplinary policy. You don't have to have 4 steps. I've seen up to 7. If that meets your needs, then that's fine. I've seen as few as 3. But it does review your policy and see if it meets your needs, and then see if you're following it. Are all of your departments following it, and are they always consistent with it? Oftentimes, these are in our employee handbooks, and we need to make sure that if they're in the employee handbook, that whatever it says in there that we're doing or that gets us into trouble. Be careful if you're doing your employee handbook that you don't write your progressive disciplinary policy so tight that you're locked into the steps. If you decide that you want to skip a step or repeat a step, you need to make sure that your policy allows you to do that. Because if you end up in a court hearing or a legal proceeding and your policy doesn't allow you to do that, and you've done that, you're going to have violated your own policy. That's never a good idea. Revise your policy if you need to, but follow it. Get it to where you can follow it. Give yourself enough flexibility that if somebody has a very serious offense, let's say that they do something very serious with harassment or safety or just physically hurting somebody, you aren't going to want to give them a first written. In that case, you may want to go right to termination, and you have to make sure that your policy allows you to do that. There are also times when it's appropriate to repeat steps. Let's say that somebody's had their third warning about some performance issues. And let's say that it's about accuracy in the work that they're doing. So they've had their third written in, and you say, well, the next incident you're going to be terminated. If the next incident is a small incident and you don't feel right terminating somebody for that, let's say it's an error that other people have made and it doesn't feel right to terminate them for that error, you can repeat the step. You can say again that, you know what, we know you're on a third written, we know you made this mistake, but we don't feel that it's appropriate to terminate you for this, so we're going to give you a break on this one. So there's times when it's appropriate to do that, but you need to make sure that your disciplinary policy allows for management discretion based on a case-by-case basis or based on the circumstances of the investigation, however you want to word that. But make sure that you have a policy that you can live with. Think twice before disciplining when others have done a similar act and not been disciplined. That goes back to the consistency. So if you could discipline employees who have done a similar act and not been disciplined if the rules have changed. For example, maybe somebody had a violation sleeping on the job, but you had no rule against sleeping on the job. Now you've created a rule that says no sleeping on the job, and now you can discipline people for it because the rule has changed. You've told them what the rule is, and you can handle it. Sometimes differences in employee records justify different treatment also. So if it's an incident of absenteeism and you have a new person that's been there for 3 months and they've missed 4 times or 5 times, and your expectation is 2 times in the first 3 months, you may treat them differently as a new hire than somebody who has been there a very long time, has a very good record, and is just going through some personal issues that they've told you about, and you know that it's going to pass. So there are times when, where it makes sense to take a look at the full picture and then make your decisions. Be careful if you think that there might be retaliation occurring. Let's say that you have a supervisor come to you and say, I think that Suzanne needs to be terminated because of some performance issues, and I've been having these problems with her, and it's just she's never gotten better. However, you know that Suzanne reported that supervisor for some illegal behavior, and so you might be concerned that there's some retaliation occurring. So you need to be very careful. You also need to be careful that employees are not setting each other up because they are capable of doing that also. If your rules are unclear, then think about whether or not it's fair to discipline somebody. If they say, well, that's not what I thought you meant, or that's not clear, consider making the rules clear, and then disciplining after that. And there's also issues with conflicting laws. Be careful when disciplining in conflicting laws, and I'll talk about those a little more. So oftentimes employers ask, must the employee sign the written disciplinary action? Or the same thing applies when I'm talking about this, the same thing applies with a performance evaluation. Do they have to sign the form? Do you have to force them to sign the form before they leave the room? No, they don't need to sign, and it doesn't change anything. You can ask them to write refuse to sign in their employee signature space, and some of them do. I've asked them, they've said, I'm not going to sign that. And I said, well, will you write refuse to sign and initial it? And they've done that. Not everybody does that. But if they won't write refuse to sign in their space, then you do it in front of them. Right? Refuse to sign, put your initials, and date it, and still give them a copy. I have on those forms any performance improvement plans, any discipline, any performance plans, that they acknowledge receipt of the information, not that they agree with the information. And so sometimes when you point out, all this says is that you're acknowledging receipt, sometimes they'll sign it. If they refuse to sign it, it still goes in their record. It doesn't change anything. You can invite them if it's appropriate. You can invite them to write a rebuttal, and then you could just attach the rebuttal to the other document. And you don't have to write a rebuttal to their rebuttal. You can just attach it to the other document. And any time that somebody sees that written performance evaluation or that written documentation, that their rebuttal should be attached to that and should always accompany that and become a part of their record. But that doesn't mean you get into a battle going back and forth on that. Just tell them that you will attach it, and it becomes part of the record. So discipline with complications. Attendance violation. Let's say a disabled employee needs more time off than is allowed by your attendance program or FMLA. The conflicting laws here are the ADA, Americans with Disabilities Act, and the Family Medical Leave Act. You may also have to look at the WFEA, the Wisconsin Fair Employment Act, in some situations. So what you need to do in a situation like that is review the medical support to see if additional time off should be expected based on the employee's disability. If the disability requires that they have more time off than is provided for under the attendance program or under the FMLA, then you may need to provide that time and not discipline them in any manner for having the increased time off. Be careful at the end of FMLA, at the end of their 20 weeks, which is 12 weeks federal, 8 weeks state, if they take the full 20 weeks, be careful that you are not terminating them if they are disabled without taking a look at whether or not you need to make an accommodation because of the ADA. Another conflicting law issue is performance. If a female salesperson didn't meet her sales goals because she was out 12 weeks for having a baby, you cannot hold that against her in her performance review. The conflicting laws are the FMLA, the Pregnancy Act, and potential for discrimination because of the pregnancy. You have to evaluate the employee's performance based on the time she was able to work, and there should be no negative consequence, no comment on her performance review, or any reference at all to a problem based on taking the legally allowed leave. So you have to be careful on your performance evaluations, any disciplinary action or anything like that for somebody taking their legally allowed leave. And finally, a safety violation. The employee suffers a work comp accident. They violated a safety rule. They were trained. They had been written up in the past, now hospitalized due to the seriousness of the current injury. Again, it's FMLA may be entering in because if somebody is on work comp, you can put them on FMLA. And you also can consider immediate termination if you've done all the steps that we talked about before. But again, when dealing with a safety violation, proceed with caution, because if you've skipped any of the steps, you may not be able to do it. And you'll be disciplining for violation of your work rules, not for getting hurt. So, other thoughts. Make sure that the consequences fit the action. If you feel like the action that you're about to take may be too severe or may not be severe enough, talk to someone who has a little more experience with you than you on this. Talk to them and see, what do you think? How does this feel? The discipline, again, should be delivered fairly quickly so that it is seen as being important, that the behavior was important, and that you're on top of it. If you haven't delivered a disciplinary action to somebody in the past, consider role-playing with somebody that's done it, because that will help you go through that process. Because if you haven't done it before, it's uncomfortable. Maintain confidentiality. Don't be posting people's disciplinary action. Don't be talking to other people about it. People have the right to their privacy when it comes to their performance and disciplinary issues. And the employees also have rights to copies of their written reprimands. So if you write them up, give them a copy of that, but you do not have to give them your investigation notes, and I never would do that. There's the safety violations reference that I had mentioned earlier about disciplining employees for safety violations. This may be of use to you for additional information. And what questions do you have?
All right. I do believe that we had some questions come through, so let me go ahead and get to it. Here we go. John asked, This one was addressed during the presentation. John asked, what is the timeline for reporting a known disability in a pre-hire? Is it something that needs to be noted in the pre-hire process?
We're kind of getting away from the documentation and disciplinary process, but I will respond to that in the Q&A that I send out to everybody. Typically, the employee or the applicant does not have to declare a disability if they are not aware that it would be make it difficult for them to do the job. I'll respond to that in a little more detail in the Q&A that I send out.
Great. So obviously we have Karen's contact information up here, so if you do find that you have some questions once you're reviewing this information, please feel free to reach out to her. As she mentioned, she will be sending out a question and answer document to all of our registrants, so you will be receiving that from her. And I'm going to go ahead and pull up the continuing education, SHRM and HRCI credit information, and please remember to fill out our survey. Thanks everyone for attending, and we hope to see you next time.